In sum, it is clear through defendant's words, Jones' words, and the representation regarding the bank records themselves that defendant cannot assure this court as to the origin of the funds used to pay the defendant's bail bond. As such, this court's findings that the defendant did not make a prima facie case that the source of the funds was legitimate is correct and should not be disturbed. So you ain't proved your case. Now, as to the authority that they were talking of when they were saying the courts don't have a right, the court has the authority to set conditions on the source of money used to fund defendant's release from the detention order. Defendant claims that this court can only examine whether the source of the funds come from a illegal substance source and cannot put forth restrictions on the source of the funds. Defendant's understanding is incorrect. This court can impose any conditions for release as long as the conditions is the least restrictive means to protect the safety of the community or to ensure that the defendant will appear. This court determined that the defendant was a danger to the community after lengthy arguments and reviews of the factors listed in NRS 178.4853. As a result, the court determined that the decision order was necessary to protect the community to set the bail at $750,000. Now, what I'm getting from this is they figured we're going to set the bail that high because we know through his assets, he ain't got it. So we're going to set it that high because we don't think he's going to get it. But my thing is,